Statement. This is to advise the general public that in compliance with Chapter 231 of the Public Laws of 1975, entitled Senator Bear Open Public Meeting Act, New Jersey Casino Control Commission on August 13, 2025, filed with the Secretary of State at the State House in Trenton, a meeting notice of today. On August 13, 2025, copies were mailed to subscribers. The use of cell phones in the public meeting room while the commission is in session is prohibited. Any member of the public who wishes to address the commission will be given the opportunity to do so before the commission adjourns for the day. Please stand for the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Welcome everyone who is joining us in person and remotely today. We have a short agenda as there are only two matters to be considered today. This meeting will be streamed, same as our regular monthly meetings. The public is able to listen through access provided on the Commission's website, as well as through our YouTube channel. We will accept public comments via email. Public comments can be sent to public.comments@ccc.nj.gov. I will repeat that. Public comments can be sent to public.comments@ccc.nj.gov, beginning now and any time throughout the meeting, ending at the time of adjournment. This meeting is being transcribed as well as recorded, and minutes will be available on our website in due course. To meeting participant callers, I ask that you follow the instructions provided with the web link or audio call-in code and place your phones on mute until your matter is called. Also, when your matter is called, please identify yourself before speaking. Thank you.
Good afternoon. Please answer when I call your name for the roll, please. Commissioner Formica.
Here.
Commissioner Molyneux.
Present.
And Chairman Pelosi.
Present.
The first matter for your consideration today is consideration of the initial decision in the matter of the appeal of CG for removal from the self-exclusion list. That is docket number 250043AP. You have Senior Counsel Teresa Pimpinelli, who will guide you through that matter.
Good morning, Chairman, Commissioners. Teresa Pimpinelli, Senior Counsel, appearing for the Commission. For your consideration is the July 8th, 2025 initial decision. You have the complete record in this matter. Appellant is present by Zoom. I believe the division is here. I would just ask both parties to enter their appearance and proceed, and I remind everyone appellant's identity is confidential.
Good afternoon, Chairman and Commissioners. DAG Letitia Fishin for the division in this matter.
Mr. CG, you can enter your appearance now. If CG could please unmute themselves and enter their appearance, please.
Hello, can you hear me? Hello?
Now we can.
Hello?
We can hear
Oh,
you now.
okay. Thank you, I'm sorry.
Sir, you have to be sworn in, Darrell.
Sure.
Raise your right hand, please. Do you swear to tell the truth, the whole truth, nothing but the truth, so help you God?
I do.
Thank you. Please, thank you.
Sure.
The division may proceed.
Thank you. So here, the division respectfully requests that the commission adopt its initial decision. Here, it was CG's responsibility to read the consequences of self-exclusion, which were set forth in about 8 steps on the self-exclusion process. As previously argued, the appellant's request for early removal from the self-exclusion list due to their failure to thoroughly read the self-exclusion terms would undermine the self-exclusion program. And because of the precedential case in Re SD, where the commission denied the appellant's requested relief, stating that the appellant had not been excluded for any unconstitutional or illegal reasons, but by their own voluntary actions. Here is the same case with the appellant here. The appellant, off their own volition, went through the 8 steps and self-excluded. So the division respectfully requests the commission to adopt its initial decision and deny the appellant's request for early removal from the self-exclusion list. Thank you.
Mr. C.G., your comments, please.
Just to respond to that, I never voluntarily put myself on this list. I was mistakenly thought I was going through a FanDuel website, which if you read the wording, it said you can no longer gamble on FanDuel. And I clicked all the steps and I went through it. I also want to note that I was under the influence of alcohol and I didn't understand what I was clicking and I didn't read anything and I click. And the next thing you know, I was on some kind of statewide ban, which I never intentionally tried to put myself on.
Here, the appellant admitted in the initial oral argument to not fully reading the self-exclusion steps before self-excluding. So here, the division does have to adhere to its regulations. NJAC 1369G 2.2 provides that the division shall confirm a patron's request to place themselves on the self-exclusion list. And again, those the confirmation that we verify with is set forth in the steps. And it is not an excuse here that the patron failed to read the self-exclusion steps. They are set forth there, and in one of the acknowledgements, it specifically sets forth that self-exclusion, the self-exclusion program will give the division permission to disseminate that information to the New Jersey state operators, and so therefore the self-exclusion would expand to exclude the patron from any gaming in New Jersey. So therefore, because of that, we have determined that the appellant did intend to self-exclude, and therefore request that the self-exclusion remains intact and the appellant is not removed early from the self-exclusion list.
Mr. C.J., did you have any other follow-up?
Yes, I understand that they're saying that I intended to sign up for the self-exclusion. However, since the week that I found out that this was happening, I've been fighting it for over a year. And the first 40 years of my life, I had no trouble gambling. So if I intended to, why would I not just say, okay, I intended to be on this list, I'll remain on it. I've never wavered since day one. I honestly was drinking. I didn't understand what I was signing up for. I feel like there should have been some kind of confirmation call or email or some notary to just say, do you know what you're getting into? Because it is a serious issue to sign up for 5 years of not being allowed to gamble online or be in casinos. So at the time, I was by myself, I was drinking, I admit it. I admit I did click boxes. I just admit that I didn't understand the severity of what I was clicking. I was under the impression that I was banning myself from a specific website because that's the website I was on at the time that I was clicking it. It was a FanDuel website. It wasn't a New Jersey state website. It was a FanDuel app that I administered this with, that I was trying to block.
Thank you. Any questions for the appellant or the division?
I have questions for the appellant. Hello, sir. My name's Mario Formica. I'm a New Jersey Casino Control Commissioner. Can you hear me?
Yes, how you doing today, sir?
I'm doing okay. Sir, in front of me, I have printed out for me the screens that are on the FanDuel app website that you have to complete before self-exclusion. Do you remember them?
I remember seeing them at the hearing
Okay.
that they printed out for me, yeah, yes.
Would you agree with me that you have to fill in your name if you want to self-exclude, and you did that?
Yes,
And you have to fill in the last 4 digits of your social security number, and you did that?
Yes, I did all that thinking that I was self-excluding from FanDuel. If you read it, it does say you can no longer gamble with FanDuel.
Sir, let me finish. Sir, let me finish, okay?
Sure.
There's also a spot where you fill in the number of years you're requesting exclusion from, correct? You remember that?
I would guess, yeah. I guess I would have had filled that out.
And it also gives you a choice to self-exclude or take a timeout. You remember that?
Honestly, I don't.
Okay.
Like I said, I was drinking that night. I really don't remember specifics. I
Okay.
remember going through a process specifically, but not not the specifics.
Okay, do you remember the waiver and release acknowledgement box that you checked?
I'm sure I checked it. If I went through with the process, I'm sure I checked it.
And you had to check another box that explicitly says, you should be aware that casino companies might enact responsible gaming programs that are stricter than New Jersey's self-exclusion program. By way of example, Atlantic City casinos may enact a responsible gaming program in which persons signing up for the self-exclusion list are banned from properties worldwide. Accordingly, you should be aware that a casino, online operator, or sports book, as a consequence of you signing up for this internet self-exclusion, may ban you from land properties. You remember that?
I would have never signed that knowingly if I understood those terms. So I checked that box. I'm not going to deny that I checked that box, but I definitely didn't understand that.
Okay.
Terms. I didn't read them or skip through it quick.
All right, it seems like a lot of steps you had to go through, am I right?
Well, it's a lot of boxes and checking, which I'm sure, like with any other contract, I'm sure like your cell phone, you just click, yes, I accept. That's probably the process that I was doing that day.
Okay.
Not knowing the significance, because
But-
like I said, I haven't wavered and said, oh, I do belong on this list for over a year and a half. So it's not that one night I just said, hey, I feel like I should be banned from gambling for 5 years. And then no other day since then have I said, that's the case. Or my first 40 years alive, have I said, that's the case. So it's just that one night where I was drinking and didn't understand. So to me, it's obvious that my intentions weren't to ban myself from the whole state. It was just that particular website.
Okay, so is it your testimony that you were able to go through all those steps? And
Yes,
che-
I admit that I must have had to go through those steps.
And check all those
Not understanding.
boxes,
I can't say I didn't. No, I can't say I didn't check those boxes.
despite the fact that you're intoxicated? Is that what you're saying?
I was drinking. I didn't understand what I was going through. I was under the impression that I was just blocking the FanDuel website specifically.
Okay, thanks a lot, sir.
Thank you, sir.
Any other questions for the commissioners?
No.
Anything else from the division? No. Hearing none. Is there a motion?
Yes, sir. Mr. Chairman, I have a motion. I make a motion to adopt the initial decision that the appellant failed to demonstrate that he did not intentionally place himself on the division's self-exclusion list as required by NJAC 13:69G-2.2C, and deny his request to be moved from the division's self-exclusion list prior to January 21st, 2029 expiration date.
Is there a second?
Mr. Chairman, I second the motion.
Any further discussion?
No.
No, sir.
Hearing none, all in favor say aye. Aye. Opposed? Ayes have it.
The next matter for your consideration is the consideration of the initial decision in the matter of the initial application of James McGowan for a casino key employee license and for plenary qualification. That is docket number 25002CK. Again, we have Senior Counsel Pipinelli, who will review that matter with you.
Chairman Commissioners, Teresa Pimpinelli, Senior Counsel appearing for the Commission. For your consideration is the July 25th, 2025 initial decision for the casino key employee license and plenary qualification of James McGowan. The division filed exceptions. You have staff's memo and recommendation for this matter. Both parties are present, and I would just ask them to enter their appearances and proceed.
Good afternoon, Chairman, Commissioners, Pacifico Agnolini from Brownstein Hyatt Farber Schreck. With me today is also William Downey, also from Brownstein Hyatt Farber Schreck. We are here on behalf of James McGowan, who is with us today in the audience. And thank you.
Good afternoon, Chairman and Commissioners. Jocelyn Fedowitz, Deputy Attorney General, appearing on behalf of the Division of Gaming Enforcement.
Good afternoon. In March of 2024, James McGowan filed an application for a Casino Key employee license and qualification, which would allow him to assume the position of Vice President of Security for Tropicana Atlantic City Corp. In response to a petition filed on behalf of Mr. McGowan and Tropicana on April 10th, 2024, the Casino Control Commission issued a temporary Casino Key employee license and temporary authorization for Mr. McGowan to serve as the Vice President of Security for Tropicana. On December 31st, 2024, the Division of Gaming Enforcement issued a report recommending denial of Mr. McGowan's Casino Key employee license for the reasons set forth in the report. Mr. McGowan requested a hearing on the matter of his licensure and qualification, which hearing was conducted before then Commissioner Alyssa Cooper over 4 days in May of this year. Commissioner Cooper issued her hearing examiner report on July 25th, 2025, wherein she stated that she was satisfied that Mr. McGowan, and I quote, had demonstrated by clear and convincing evidence his good character, honesty, and integrity, as well as his financial stability, integrity, and responsibility required by NJSA 5:12-80, NJSA 5:12-86A, NJSA 5:12-86B, NJSA 5:12-89B1, and NJSA 5:12-89B2 of the Concealed Control Act, end quote. Commissioner Cooper then found that Mr. McGowan, quote, possesses the requisite qualifications for licensure as a Casino Key employee, end quote, and further that he, quote, is qualified to hold the position of Vice President of Security at Tropicana Atlantic City Corp., end quote. Based on these findings, Commissioner Cooper recommended that the Commission, one, grant Mr. McGowan's initial application for Casino Key employee license number 10936-11, and two, grant his pending request for plenary qualification to serve as the Vice President of Security for Tropicana. After 4 days of testimony, both direct and cross-examination, and hundreds of pages of documentary evidence, Commissioner Cooper correctly concluded that Mr. McGowan possessed the statutorily enumerated criteria for licensure and qualification, specifically that he possessed the requisite good character, honesty, and integrity. We have thoroughly reviewed the hearing examiner's initial report and the division's post-hearing submission, to which we have responded in writing. Based on the foregoing, we agree with the conclusions reached by Commissioner Cooper in the hearing examiner's report and ask that the Commission adopt the hearing examiner's initial report as the Commission's final report, issue Mr. McGowan his Casino Key employee license, and find him qualified to hold the position of Vice President of Security at Tropicana Atlantic City Corp. Thank you.
Division.
The Division of Gaming Enforcement is in receipt of the initial decision issued on July 25th, 2025. On August 7th, 2025, the division filed its exceptions to the initial decision, which have been marked as Exhibit D1, in response to the initial decision. James McGowan applied for a Casino Key employee license and qualification as Vice President of Security for casino licensee Tropicana Atlantic City, as required by the Casino Control Act and the regulations promulgated thereunder, the Division of Gaming Enforcement conducted an investigation of James McGowan's qualifications for licensure. As set forth in the division's report dated December 31st, 2024, the division raised concerns regarding James McGowan's ability to demonstrate good character, honesty, and integrity as required by Section 89B2 of the Casino Control Act to the statutory standard of clear and convincing evidence, as well as James McGowan's candor pursuant to Section 86B of the Act. With respect to James McGowan's good character, honesty, and integrity as required by Section 89B2, the division's report cited to a half-dozen internal conduct complaints, as well as lawsuits filed against James McGowan or naming him as a defendant as applicable during his career with the Division of State Police. Moreover, the nature of some of the aforementioned complaints called into question James McGowan's candor as required by Section 86B of the Act, as well as his forthrightness regarding the disclosure and status of, as well as factual information regarding such complaints and lawsuits in his personal history disclosure form and during the division's investigation. Accordingly, the division requested that the matter proceed to the contested case process so that a hearing examiner could determine credibility in light of the derogatory information detailed in the division's letter report, and whether James McGowan could demonstrate good character, honesty, and integrity to the clear and convincing standard necessary for casino key employee licensure and qualification. The contested hearing was held over the course of 4 days in May, resulting in the initial decision issued on July 25th, 2025. Some of the main points that the division noted in its filed exceptions involve the division's witnesses, their credibility, and the weight afforded to them by the hearing examiner. Specifically, the initial decision indicates that one of the division's witnesses did not testify during the hearing, but fails to note the background resulting in the lack of live testimony and the related motion practice regarding this witness and the certification submitted into evidence. As further detailed in the division's filed exceptions, the division was denied due process in relation to the improper issuance of a subpoena for certain of the witnesses' records, which forced the division to adjust its strategy on the eve of the hearing and submit a certification of the witness in lieu of live testimony, and the subsequent motion practice in which the hearing examiner initially issued an order before affording the division the opportunity to respond. The aforementioned background regarding the subpoena, events surrounding motion practice, and related orders were not mentioned in the initial decision. Moreover, the initial decision failed to afford proper weight to or even consider the certification, which equated to the witness's honest testimony and failed to make any formal finding of fact as to the witness's allegation against James McGowan. Additionally, the initial decision scrutinizes the testimony of another division witness, noting that charges against that witness were sustained by the Division of State Police Office of Professional Standards. However, the initial decision ignores the findings in the Office of Public Integrity and Accountability report, as well as the Attorney General's press release addressing the findings of the report, both of which recommended that the charges against that witness be vacated due to the Office of Professional Standards investigation's lack of neutrality, and it was so directed. This information is significant and should have been considered in the hearing examiner's assessment of the hearing testimony. Further, as set forth in the division's filed exceptions, the initial decision incorrectly places the burden on the division to demonstrate, by a preponderance of the evidence, that the applicant is disqualified under Section 89 of the Act. However, the obligation to satisfy the criteria under Section 89 remains the affirmative burden of the applicant alone to demonstrate, by clear and convincing evidence, their qualifications for licensure and/or qualification, and this burden never shifts to the division. The division relies on the entire record in this matter, including the motion proceedings and its exceptions, and especially the hearing testimony and exhibits. The division respectfully requests that the commission take into consideration the points set forth in the division's submission, and based upon a review of the entire record in this case, accord them proper weight in its determination of James McGowan's application for plenary casino key employee licensure and qualification, and make additional findings of fact and reanalyze the matter, considering the points raised in the division's exceptions. Lastly, the division requests that the division's letter of exceptions, marked as Exhibit D1, be moved into evidence. Thank you.
Going back, Mr. Chairman, to mark the respective exhibits so that that piece is addressed.
Yes.
Yes, so we believe that the division submission, the exception submission, and our response are pleadings in this matter and therefore don't need to be marked. But we have no objection to them being marked, and we would ask that, that our response to the division be, which has been marked as A1, be entered as well.
Yes.
Thank you.
Chairman, may I
Yes,
just, I don't, if, in responding to the division, I believe that the points raised by the division were raised in their submission, their post-hearing submission. We addressed those points in ours, and I don't believe that needs to be restated. So we'll rest on the record and would again just ask that you adopt the hearing examiner's initial report as the commissioner's final report and issue the casino key employee license and find Mr. McGowan qualified to hold the position at Tropicana. Thank you.
Just accept the exhibits.
Or accept the,
A1 and D1.
A.
Sorry, what's the,
You say them for the record, so that,
yeah, the exception is which one?
Yes, we have two exhibits.
Yeah.
Ready.
So the division's exception was marked as D1 and
D1.
our response was
Thank you.
marked as A1.
Thank you, thank you, thank you, thank you.
and to the extent there is no objection, Mr. Chairman,
yes.
you want to move the exhibits?
Okay, we'll move to accept those exhibits. Do we have a motion?
I make a motion to accept those exhibits.
Have a second?
As D1, A1.
I second the motion.
All in favor? Aye. Opposed? Ayes have it. Are there any questions for council?
I do.
Commissioner?
Question for counsel for the division. Ma'am, I'm looking at your exceptions. First one, which starts on page 2 of D1, the correspondence of August 7th, and I'm paraphrasing maybe. The initial decision failed to set forth relevant, significant background and procedural matters with regard to the seriousness of RG's allegations. You with me?
Sorry, you said page 2?
Page 2 of your August 7th exceptions, which is D1. Page 2 at the top. You got it?
Yes.
Okay, and help me out on this, because I may be wrong. By way of background, what I read, counsel for JWM issued a subpoena for RG's appearance and seeking production of her medical records, which the division claimed were invasive and intimidating and procedurally deficient. Do I have that right?
Yes, I believe the subpoena was for the medical records. Off the top of my head right now, I don't have it in front of me. I don't know if it was to appear, but she had advised the division prior to that that she was planning to appear as a witness for the
Okay.
division.
So I guess we have my next point. We find out that RG didn't want to testify. She said it would be too traumatic, right?
Yes.
And then the division says, in an attempt to remedy her inability to testify, they offer a certification, correct?
Yes.
And Mr. McGowan's attorneys filed a motion to quash, then they withdrew the motion, and then the certification became part of the record.
Yes.
Okay.
And just for clarification, the motion to quash was for a portion of the subpoena.
Okay.
Not the entire, or I'm not the subpoena, I'm sorry, a portion
motion.
of the certification,
Right.
not the entire.
Thank you. I'm just wondering, the certification came in before the hearing examiner, right?
Yes, it was entered in as an exhibit.
Just wondering how that procedural history was relevant or significant. Because that's your exception.
Yes, the procedural history that was relevant and significant that wasn't noted in the initial decision involved the issuing of the subpoena without the division's knowledge prior to issuing that subpoena, and then the fact that it was for medical records that the division asserts were not relevant to this, whether or not the alleged statement that the witness alleged that Mr. McGowan made to her was actually stated or not.
Okay.
And so there was motion practice back and forth regarding that. And then the division was denied its due process in not being afforded an opportunity to respond to the motion to quash before the commission issued an order. And then the division responded after the fact, and then the motion was ultimately withdrawn.
Right, the certification came in is what I mean, right?
Yes, ultimately.
Let me ask you this then, with regard to substance. You would agree with me that the certification's not subject to cross-examination, right?
Correct.
But following his direct testimony before the hearing officer on May 7th, Mr. McGowan was subject to cross-examination, right?
Correct.
Now, in your opinion, I guess in general, I suppose, would live testimony that is subject to cross-examination provide a fact finder with a better basis to determine veracity as opposed to a certification?
For that witness, correct. For the division's witness, our main point was that she was willing to testify until she received the subpoena.
Okay. But what was before the hearing examiner was live testimony of Mr. McGowan subject to cross-examination versus a certification, correct?
Correct.
Thanks. Now, one more thing. This isn't listed in your exceptions, but a large part of the division's rejection, and that rejection of December of 2024, was devoted to a discussion of complaints lodged against Mr. McGowan while at the New Jersey State Police. Do you have that rejection letter in front of you? The December 31st, 2024? I guess that would be part of the pleadings too, right?
Yes, I have a copy.
Okay, thank you. The division noted that there were a total, including RG, 6 instances of conduct complaints filed against Mr. McGowan in, was that 27 years at the New Jersey State Police? And that's at the top of page 4 of the division's rejection letter. Do we have that? Yeah, right at the top of page 4. 6 total instances in which conduct complaints were filed against JMW, right? You got that, Ms. Fedowitz?
Correct.
Okay. Can you tell me how many either were dismissed, administratively closed, or unsubstantiated by the Division of State Police Professional Standards?
I believe all of them were either administratively closed or unsubstantiated or unfounded.
Nonetheless, the division's rejection letter gives a lot of attention to a 2021 internal complaint alleging that Mr. McGowan failed to report that one of his subordinates made a negative comment about another employee's promotion based upon race, and I'm looking at the middle of page 4 of the December 31st, 2024. Middle of page 4. And then right below that, the division cites another internal 2022 complaint against Mr. McGowan arising out of the 2021 complaint, this one alleging that he provided false information with regard to the 2021 complaint. Are you with me?
Yes.
Am I right about that?
Yes.
And I get why the division wanted to include that because according to division, those two complaints are referenced in a 2024 report conducted by the AG's office. Mr. McGowan wasn't mentioned, but the complaints were referenced, right?
Correct. The complaints and the scenario that relates to the 2021 and 2022 complaints were referenced and discussed in the Office of Public Integrity and Accountability report.
Gotcha, thank you. So then I turn to page 5 of your rejection letter, and I'm looking at the last sentence of the first full paragraph, and I read, the 2021 complaint filed against JWM regarding these matters, as well as the 2022 complaint, was closed and unfounded and dismissed. Is that correct?
Sorry, it was page 5?
Page 5, last sentence of the first full paragraph. Meanwhile, as set forth above, the 2021 complaint filed against JWM regarding these matters, as well as the 2022 complaint filed against JWM related to the OPS investigation of the same, was closed as unfounded and dismissed. Do you see that? Page 5 of the rejection letter of December 31st, 2024, page 5, last sentence of the first full paragraph on page 5, starting with meanwhile.
Okay, yes, I see it, yes.
Got it. Okay. Now, that finding, unfounded and dismissed, wasn't from internal affairs from the state police. That was found by the Attorney General, right?
I believe if I'm understanding it correctly, the OPIA report
Right.
references that the Division of State Police, OPS, closed it and deemed it unfounded and dismissed it.
Okay, thanks. That's all I have.
Any other questions?
No.
No, sir.
Is there a motion?
Is this a roll call vote?
Yes.
Yes.
Okay. Yes, sir, there is a motion, Mr. Chairman. I make a motion to adopt the initial decision with a modification. Reference on page 12 in that initial decision, it says then New Jersey Attorney General Gruol. That be replaced with a reference to then New Jersey Attorney General. And thereby, motion also to grant the applicant's initial application for a casino key employee license and also find the applicant plenary qualified to serve as Vice President of Security for Tropicana Atlanta Corp.
I'll second that motion. Any further discussion?
No.
No, sir.
Hearing none, roll call vote.
Commissioner Formica.
Yes, here.
Commissioner Molyneux.
Yes.
Chairman Pelosi.
Yes.
In accordance with Resolution 24121103, the next closed session shall be held on Wednesday, September 10, 2025, at 9:30 a.m. in the Commission offices.
Thank you.
Thank you.
Thank you. This is the public participation portion of the meeting. Is there anyone from the public that wishes to speak?
I have no remarks from email, Mr. Chairman.
The public participation portion of the meeting is now closed. Do I have a motion to adjourn this meeting?
I make a motion to adjourn the meeting, Mr.
Do I have
Chairman.
a second?
Mr. Chairman, I